Okay, council, we are live streaming right now, so if anybody's gonna take a phone call or somebody walks in your office, please make sure you are on mute, please. Okay, Vince,
Yes.
did you call me or no? Somebody called me.
Well, I believe council or the movement on number 11 is here now. Just wondering if we were getting.
Are they?
That's
Oh,
me, Pete.
Hey, Jonathan, there you go.
Appreciate you commenting my email.
Yep, absolutely. So, okay, so Jonathan, the Henry matter is case number 11. Clemens matter is case number 21. So I know 21 is not going to be worked out. So let's go into room 11 with Vince. And Vince is maybe a more reasonable man than Eric is. I'm not quite sure.
Eric's reasonable
We'll
too.
see.
Everyone's reasonable, Pete. We all just have our positions, right?
All right, I like that. I like that. All right, there you go. All right, just wanted to wake up Eric there. He looked like he was watching that baseball game last night. Going,
Yeah.
Let's forget about that, please.
well, you know what? I was down there
Ooh.
and I seen a no-hitter, so I'm okay.
There you go. You've seen history.
Okay. I seen a no-hitter. It's okay.
You weren't alive for the last
The
one.
other side had the no-hitter, but what are you gonna do?
Yeah.
We're right where we want them.
Yeah.
Phillies in 6.
I said that from the beginning, so tonight's the game. Whoever wins tonight probably wins the World Series.
I agree.
Yep.
Oh, here we go. Vince, Jonathan, go in the breakout room number 11.
You got it, Pete.
Awesome.
But I know how to piss off your wife. Stay all the way for a no-hitter. That'll piss her off, all right?
Yeah.
So everybody go in the breakout room number 11 there. If you need help getting in, let me know.
You don't want me in 11, do you?
No, you're not gonna work.
Yeah, I'm gonna wait. Okay.
There you go.
Oh,
Okay, did anybody work anything out in the breakout rooms? All right, I'll take that. No response for a no. So let's go through the list. Case number 1, I have a movement and an observer right now. All right, it's only 9:12. They got 3 more minutes to show up. Case number 2 is in a breakout room. Case number 3. Case number 3.
Hey, Pete and Al, on that case number 1, I read through the plaintiff's response. Did you read through that? Because it says that they're basically going to comply within 20 days of the court's order, if I read that right.
Yeah, they filed it as an opposition,
Right, so that's why I
but
got right.
I mean, basically, I think their order takes out the monetary sanction.
But we'll wait. They got 2 more minutes to get here. If not, then it goes in as uncontested and you'll send
Okay.
me over your proposed order, and then the judge will look at it.
All right, thank you.
Yep, thank you, Rebecca. Case number 7. Anybody here on 7 right now?
I think that's us, Pete, right? The Etchegatory Laura.
Yep, so that's still contested, right?
Yes, it is.
Yep, gotcha. Case number 8. We're in a breakout room 10. Roger out of here. Stephanie. Stephanie, did you get a list? Okay. Case number 2, we work anything out?
We were unable to work anything out.
Okay.
Thank you.
Yep. Case number 1, it is now 9:15. Move it. Observer only. Al, I'm going to ask you to email me the order that you filed with the court. That motion is deemed uncontested by the court. All right?
Thank you. That's to Peter Devon at courts.villa.
You got it, Al. All
Thank
right.
you very much.
Thanks, buddy. Take care, everybody. See you, Rebecca.
Bye-bye, take care.
All right, case number 2, still contested. Anybody here on 3 right now? They're gonna still in a breakout.
Yes,
room.
Pete, we're here. We're back. We cannot resolve it.
All right. Gotcha. Thank you. Case number 7's here. That's okay. Case number 8's in a breakout room. And I got 10. I got 11. Case number 13, Maxie. Who's on case number 13, Maxie?
The move-in's here. I don't believe the respondent is.
Oh,
Steve, I actually am the respondent on that, but I filed an opposition to the motion before a motion to withdraw my appearance in the case was granted. So I'm actually withdrawn from the case now, although I did file an opposition to the motion before I was withdrawn. I don't know how you want to handle it.
But you filed a motion to withdraw, correct?
I did file a motion, it was granted, and I have filed a withdrawal of appearance as well. So I don't know if I have to appear on that or not.
Well, did the judge grant you to?
Yes,
All right, so the judge granted you, so you filed a motion, the judge granted you leave to file
a withdrawal of
a
appearance.
withdrawal, and you did that, correct?
That's correct.
All right, so let's see what else. I'm gonna just, let me check the docket if the judge, did the judge in that order, when she granted you to leave to withdraw, put a stay on this case, or just let it go as a pro se litigant?
That's a good question.
There was no stay. I have the order in front of me.
Okay, so there's no stay,
Correct.
roll of appearance of counsel. I'm looking at the order as we speak right now. Further order to file precedent withdrawal, an arbitration hearing is scheduled for March 14th, blah, 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 blah. No stay. So case number 13. So let's see. Does your client have notice of this hearing?
Yeah, I sent it to him.
Okay, so case number 13 is uncontested.
Very well.
Ask Manuel to email me the proposed order.
Peter,
that's
what's your,
filed with the court, okay? It's Peter dot Devon, D-I-V-O-N, at courts.villa.gov.
it's DIVON?
Yep,
All right, thank
No.
you, Peter.
you got it.
You don't need me for anything on that, right, Pete?
No, that's it for 13.
Okay, thank you, Peter. I'm gonna leave.
Yep, you're dismissed. Thank you.
Take care.
Okay, so here's the rundown. 21, 18, 19. They were all the ones that we brought back. And then we're going to go straight down the list. 2, 3, 7, 8, 10, 11, then an emergency, 23.
Pete, I apologize. There's another motion that I was originally scheduled on here for today, Sanders Bell.
That was withdrawn.
It was withdrawn. Okay, just wanted to make sure.
Yeah, that was withdrawn.
Okay.
That was from last week or something, right?
That's correct.
2 weeks ago, something like that. Yep.
Okay.
Gotcha. Mr. Maxey. You're here for a motion?
Yes, sir. I'm not too familiar with the law.
Okay, so you are a pro se litigant, okay? On this case. There's a motion in front of you. I'm not quite sure what the motion's asking for, but counsel was already here.
Okay.
We release counsel because discovery court starts at 9.
Okay.
Okay, not a problem. I want to see what the order says. Maybe a straight order. I'm not quite sure what we got here. Give me 1 second. I will.
Little.
See what we got here. Give me 1 second. Look at the top, okay? See what they're asking for. Mr. Maxey, I am going to put you in breakout room number 1. I'm going to send you an invitation. Click on that. And I'll be there in a couple minutes. Just hang loose, okay?
Okay.
Thank you.
Hit join.
Yep. Okay, I'm gonna ask all council to put your video up.
Pete,
Yes.
we worked something out. Wasn't sure if I could jump in here.
Sure, go ahead. I love when they work them out.
Yeah. Number 8, we've come to an agreement. We'll split the no-show fee, agreement to pay, plaintiff's counsel is going to pay $500 to be paid at settlement of verdict. I can send a revised order.
Please do CC all council to make sure they agree with all language, okay?
Will do.
Thank you, appreciate it. Case number 8 is by agreement. Thank you.
Thank you.
Thanks, Pete.
Here's AJ. One minute. Case number 21 will be first. Then 18, 19, 2, 3, 7, 10, 11, and 23 is the emergency.
Peter, are the breakout rooms still open?
They are.
All right, I'm assuming that AJ now is back in the office, so if he's able to join me in the breakout room, that would be great.
Okay, AJ, did you hear that?
Yeah, I switched from my phone to my computer, Pete. I don't know why I'm not in the breakout room because
All right, I'm
I
gonna
tried
do
to
that
join
right
it.
now. So that was, John, what case was that?
19.
Case number 19. I'm gonna put you, AJ, you are in 19. Click
Okay.
on that. John, go ahead in the 19. An emergency, we work that out or no?
No, sir.
Okay. It's 23, gotcha.
AP,
Mesereau,
number 18. We have worked out our differences. We are in no need of court assistance.
the motion going to be by agreement or is it going to be withdrawn?
It's going to be withdrawn, Pete. Number 18.
Number 18, withdrawn without prejudice.
Yep.
Thank you. All
Thank
council
you.
may go.
Thanks, Pete.
Yep,
Thanks, have a
go
good day.
Phils.
Go Phils.
Stephanie, did you get a list? Are you good?
No, I don't have a list. Did you send it already? I didn't check.
I'm going to send it right now. I'm just gonna
Okay.
do it real quick here from my phone.
Okay.
I'm going to take a picture of it and then send it over to you. That'll work for today.
Pete, number 19,
Yes.
we've reached an agreement, but I need to prepare a revised order.
Okay, so when you get the revised order done, CC over to AJ. AJ will review the language. Everybody agrees on it, get it back, then send it to me. I'll get it down to the judge for review. Okay?
All right, Pete, what's the best way for us to get it to you? Want me to just email it to you or should I file it?
Well, no, email it. Either email it or carrier pigeon. I mean, I got the pigeons here on the ledge.
Oh, nice.
Yeah.
Yeah,
so-
but they're all over at your end. I can't get the pigeons to come over here.
Well, I'll whistle them to you. They'll come over to you. Don't worry about it. And if it's a
All
heavy package, I send the Hawk over, okay? We use the Hawk for heavier packages, all right?
State Farm's got the big bucks. When you get that hawk going.
There you go. All right.
All righty, thank you both.
Just
I
email it
appreciate it.
over. Thank
This
you.
is number 19.
Correct. Thank you.
All right, thank you
You
both.
guys.
This is the original motion. It's filed. Apply to that. Gotcha. I got it. Yep. Okay. Yep. All right, Stephanie, I'm sending this over to you right now.
Okay, thank you.
Steph, I'm not really quite sure why this ain't sending. I'm not getting any emails in either, so we may actually have a problem here.
Good morning.
The Commonwealth of Pennsylvania, this Court of Common Pleas Civil Trial Division is now in session. The Honorable Abby F. Flippin presiding. Good morning, Your Honor.
Good morning.
Your Honor, your first case on your discovery list today is case number 21. At this time, I'm going to ask all counsel who is not on case number 21 to please shut your video down and mute your mics. Only counsel on case number 21 will appear. Case number 21, I'm going to ask to move it, to identify yourself for the record and who you represent.
Good morning, Your Honor. Jonathan Rosenell on behalf of plaintiff Timothy Clemens.
All right, good morning.
Responded.
Good morning, Your Honor. May it please this honorable court, Eric Applebaum on behalf of the respondent, Edward Frame.
All right, good morning. All right, I'll hear from the movement.
Your Honor, this is plaintiff's motion in the form of a motion for sanctions asking for an adverse inference at the time of arbitration or trial. There is no underlying motion to compel in this case, as defense will point out, because there can be no motion to compel entered on this case. By way of background, Your Honor, this is a motor vehicle accident.
All right, what are you saying was spoliated?
It's information regarding a witness and the witness's contact information. The defense had in their possession pre-suit the working phone number for a witness and took when I say the defense's carrier, Progressive, had in their possession the phone number and contact information for a witness who they took a recorded statement from that backs up plaintiff's position in this alleged he said, she said intersectional motor vehicle accident case. That information was not turned over. The witness was not identified in interrogatories. Defense counsel will say, well, it was his client who was unaware. That's why they didn't identify. But the standard interrogatory for the arbitration program says client or their representative, including counsel. So at that point, they should have turned over the name of the witness and the phone number for the witness.
Did you have a statement?
I do have the recorded statement, and I'm asking for the ability to read in that statement because since that time, after I filed the motion for sanctions, I did get a phone number. The phone number is since disconnected. The person's name is a fairly common name. I'm not sure if I can say it here on public record, but it's Sean Kemp. It's nothing that unique. When I did a Lexis search to identify all Sean Kemps within Pennsylvania, there are over 100. In Philadelphia County, there are dozens. When I hired an investigator, no one came back with that who allegedly witnessed this accident. This phone number is no longer associated with anyone named Sean Kemp.
So they gave you the phone number?
After I filed a motion for sanctions and after it was disconnected. So that's why there can be no motion to compel, because they could not be compelled to provide anything other than the phone number, which is now spoiled because it is a disconnected, unworking phone number. When at the time they had this statement, it was obviously a working phone number since they had.
Why is that obvious? How do you know that?
Because they had the opportunity to speak and interview this person in a recorded statement, and they produced that statement of this witness's own words, saying that he saw the accident, that he saw the defendant speeding, that he saw the defendant hit the plaintiff's vehicle on the side of the car, not the other way around.
Okay, so what's the time? So when did you ask them for this identifying information?
The specific request for the witness's contact information was in September, but the interrogatory was
September of
this year.
Okay, and when did they give you the witness statement?
The witness statement was several months prior to that.
Okay, and okay, so you asked them in September of this year to provide contact information.
To provide contact information for the witness of the recorded statement who was not identified in.
I understand. And when did you get the phone number that doesn't work?
2 days after I filed the motion for sanctions.
Yeah, when was that?
The date was, let me pull the email. I'm sorry, Your Honor.
Your Honor, if I may, I
You
can
may
answer that.
not. You may not.
Bear with me, Your Honor. I court's indulgence for one moment. I know it's in their responsive filing, and give me 1 second and I will pull that responsive filing. Here it is.
So I'm sorry, you don't know when you got the phone number? You need
No,
to.
I do. I'm opening the document on my computer. I apologize for not having that directly in front of me at the moment. It was by way of email dated September 26th, and that was 2 days after I filed the motion for sanctions.
So when you said you asked for the info in September, when did you ask? When in September did you ask?
My email to the defense was the 14th of September. And I said, please provide the email. It says, Mr. Applebaum, Progressive Producer, recorded interview.
I don't need to know what the email said. So what makes you think that the phone number was good on September 14th, but it wasn't good on September 26th?
The issue was that it was at some point good, and if they had turned it over at the outset of litigation, instead of denying, saying he said, she said, when they know this wasn't a he said, she said case, including pre-suit when they said it's a he said, she said case with no independent witness, when they knew of an independent witness, all of this information, they're making false statements. They can't say there's no witness. They can't say there's.
When did they say there was no witness? I'm trying to understand the chronology here.
Pre-litigation, as well as during discovery, in the answers to interrogatories.
Okay, when did you get the answers to the interrogatories and what's the date of the statement? I'm trying to understand if.
Defendant's answers to interrogatories was a 2/7/22.
Okay, so on 2/7/22, they said no witnesses.
Correct, Your Honor.
And when did they give you the witness statement?
That was within documents that same date.
Okay, so in February, they answer interrogatories and they say, we don't have any witnesses, but at the same time, they produce a witness statement. Is that right?
That is correct.
Okay, and then you wait 7 months to ask them for the identifying information on that witness. Is that right?
That is correct.
Okay. All right, Mr. Applebaum, why did you say you didn't have any witnesses at the same time that you produced a witness statement?
Correct, Your Honor. I represent Mr. Frame. Mr. Frame was not aware of any witnesses. These were his answers to interrogatories, and he said he was not aware of any witnesses. Mr. Frame was deposed by Mr. Rosenau. He never heard of a Sean Kemp. He doesn't know him, so he was honest and he verified he didn't know him. But in the production request,
Mr. Applebaum, in February, did you know that there was a witness statement?
Yes, Your Honor, we produced it in the responses to production of production requests.
And why wasn't that statement in your client's possession, custody, or control? It's his insurance company.
Right, it was between the insurance company is the one who made the phone call, not my client. The insurance company had the phone call with this Sean Kemp. My client doesn't know who Sean Kemp is.
Why didn't you give Mr. Kemp's phone number in February?
Didn't have it. And I followed up with the insurance company. And then when I finally got the phone number, I sent it to counsel on September 26th.
Well, why shouldn't I allow him to use this statement at trial?
Because we produced it. And on top of that, Your Honor, if you look at the report.
So yeah, you produced it. So why shouldn't it be allowed to be used?
Because it's hearsay.
Yeah, but you didn't give him the means to find the witness.
We did it. We gave him the statement and all the information we have. That's not my client's fault.
It may not be your client's fault, but it's your fault.
Your Honor, we produced it. It's not my fault either. We produced what we had. And in the recorded statement, the witness wrote down in the statement that he went up to the plaintiffs and told the plaintiffs, if you need my number, because I saw the accident, I'll give you my number. So the plaintiff should have had the information from this witness. It's not my client's fault or my fault. We produced everything that we have and we gave it to them. I would love to depose Mr. Kemp. I would love to talk with him.
Well, did you want to do anything to try to find him?
Yeah, well, the insurance company called them. They spoke with them.
Okay, I'm going to try this again. Did you, Mr. Applebaum, you just told me you would love to depose him. So what did you do to find him so you could take his deposition?
We did not notice him for deposition, Your Honor.
Okay, I'm going to try. I'm going to ask the question a third time. What, if anything, did you do to find the witness who you just told me you wanted to depose? Is the answer nothing? Okay.
Nothing.
Okay. Well, you really must have wanted to depose him, Mr. Applebaum. Is the statement attached to something?
It's Exhibit B on plaintiff's motion. B is in boy. Your Honor.
Okay, just give me a minute. Yeah, so Mr. Rosa, if the defendant himself didn't know about this witness, why would, what's wrong with his interrogatory answers?
Because the standard interrogatory instruction that this court universally uses and applies for arbitration matters, the only interrogatories that were allowed and permitted to propound upon the defense states that it's if the defendant or their representative, including counsel, knows of any information, they must disclose. And they did not. And it's not that they can just put it in a document. They must disclose in their answer. And Your Honor, I can share my screen to highlight that section of the instruction that this.
No, you can't. You can't. We don't allow you to share screen.
Excuse me. Well, it's page 1, paragraph 2 of the interrogatory.
Did you take Ronnie's deposition?
The insurance adjuster?
Yeah, the guy who took the statement.
No, the adjuster is someone else at this point. It's a different person. I've never spoken with or corresponded with Ronnie. It was always someone else. Mr. Roush is the person that I corresponded with throughout pre-suit and litigation.
And didn't your client know about this witness?
He says he did not. So he was deposed. Again, the depositions took place after the motion for sanctions were filed. So these were not before. The depositions were October 4th, I believe. So a week after the information was disclosed. No party says they knew of any witness named Sean Kemp.
All right, I'm granting the motion in part. I'm only granting paragraph 4, that plaintiff's entitled to read the statement into evidence. So that's the ruling.
Thank you, Your Honor. I have one more matter, so I'm going to hold until Mr. Devon calls the other matter later in the list.
All right,
Your Honor, may I
thank
be
you.
excused?
Yes, you may be excused.
Thank you.
Next case, Your Honor, is case number 2. Case number 2. I'm going to ask the movement to identify yourself for the record and who you represent.
Catherine Rayner for moving defendant Karen Duff Inc.
Respondents.
Melanie Cordero Dan.
Daniel Grandinetti on behalf of the plaintiff, Steven Stanicki.
Melania Cordero on behalf of the city of Philadelphia. I also filed a response in favor of movement's petition.
Okay.
Kristen Walfer in favor of defendant PennDOT. I also joined in the motion.
Your Honor, we lost your video.
Oh, all right, thank you.
There you go.
I was
Yep.
trying to get banner happening, so.
Yeah, we're having a little problem, I think, here. I'm not quite sure.
Okay, just bear with me.
We'll be back.
Okay. All right, I'll hear from the movement.
Good morning, Your Honor. We're here today on a second motion for preclusion to preclude the plaintiff from presenting evidence testimony at the time of trial. This comes from an ongoing discovery dispute. We originally served discovery requests on plaintiff back in February of 2021. Since that time, we've gotten 3 separate court orders, one on the motion to compel, one on a motion for sanctions, and most recently, a motion for preclusion that stated that if plaintiff did not comply within 45 days, which ended on October 3rd, that they may be precluded from presenting evidence or testimony at the time of trial.
Okay, and I'm sorry, is this, you never got any responses?
So we did receive unverified responses to interrogatories, but no document production. So our issue is that we're concerned with the veracity of these answers. They were not verified by the plaintiff. And since then, we have not been able to get those answers verified or get any document production so that we can assess damages and other matters in the case. I will represent that plaintiff has informed us that the plaintiff had a stroke in April of 2021. We have not been able to get any records until just yesterday. There were limited records from his April 2021 hospitalization provided. However, because we have not gotten the post-hospitalization rehab records or anything else, it's still unclear what plaintiff's capacity is at this time, or if he's even able to participate in this litigation.
Okay, and what's, you're currently scheduled for arbitration in January? Is that the current schedule?
That's correct. I believe the 25th.
Okay. I'm sorry, there's someone here with a blurred screen. You have to unblur. It's not permitted in the court procedures. Okay, do I have a plaintiff's counsel here?
Yes, Your Honor. Dan Grannetti on behalf of the plaintiff. Everything that defense counsel has represented to you is accurate in terms of the motions. The issue that we've continued to have with my client, unfortunately, is that he had a stroke on April 28th of 2021. We quite literally received the records from the plaintiff's girlfriend, who's been the only one that's been able to talk to us about anything that's going on as far as his medical treatment and everything. We received.
I mean, I don't want to, we are live on YouTube, so I don't want to get too deeply into the plaintiff's medical condition, but I mean, is he able to sign a verification at this point?
He has not been able to at least that's what we're told from him and from his girlfriend. We've heard from him a couple times. Recently, we haven't been able to talk to him. It's been primarily just his girlfriend that's been speaking to us.
Where is he? Is he in a rehab facility? Is he home? Is he?
From all the conversations, he's in and out. So sometimes he's at home when he's doing better. He's gone back to the hospital a couple different times. The last time we had any conversation with the girlfriend, he had just gone back to the hospital again because he had other complications and was having seizures and stuff, and he's been unable to communicate. We've been trying to see if we get anybody that has a power of attorney to, sign off on anything for him.
How about going to visit him? How about going to see him in person when he's doing better and getting him to sign a verification? I mean, if he wants to proceed with this case, you got a lot of defendants here. We got to do something to move this forward. I mean, what are you asking me to do? Just deny the motion?
I honestly, Your Honor, I would like the motion tonight, but we were trying to discuss and figure out like the best way for me to, if he can't actually sign off on it, would I just go and verify that he was the one that was able to sign it, or should I get a video of him saying that he accepts the answers? Like the way that we gave the informal discovery was by having him basically get the questions relayed to him over the phone, and then he was able to talk quietly, I guess. I heard him speak to his girlfriend for the answers to verify him through that, but other than that, I guess the issue.
Right, but that's my point. Is if he's talking and he's talking to the girlfriend, then I mean, it doesn't even sound like you've asked or tried to go in person to see him.
We haven't tried to go to see him in person, Your Honor.
Well, I'm giving you 30 days to provide full and complete verified answers, or if you really can't for some medical reason, then you're going to have to come with some medical documentation or something. I mean, we can't just indefinitely continue this matter when, quite frankly, it doesn't seem like you or your firm is doing much to try to move this along.
Your Honor, you still there?
Yep, I am. I'm just writing out the order. Sorry.
Lost, no, we lost you there.
Oh,
Yeah.
okay.
It's-
Okay. So I'm denying the motion without prejudice to renew it if plaintiff fails to comply with the prior discovery orders within 30 days. If plaintiff does not comply or provide medical documentation of his inability to comply in that time period, preclusion may result.
Thank you, Your Honor.
Thank you, Your Honor.
All right. All right. Thank you, everyone. Well, and I'm sorry, did defendants want to say anything before I?
No, that's fine, Your Honor.
No,
Okay.
Your Honor. Thank you.
Okay. All right.
Thank you.
Thank you, everyone, and you're all excused.
Thank you.
Thank you, counsel. You'll get a notification of your order. Next case, Your Honor, is case number 3. Case number 3. Going to ask the movant to identify yourself for the record and who you represent.
Penelope Salufo of Stradley Ronan on behalf of the defendants.
All right. Good morning.
Good
Respondent.
morning.
And good morning, Your Honor. My name is Sarkis Dharamgachin on behalf of the plaintiffs.
Okay. Good morning. All right. I'll hear from the movant.
Thank you, Your Honor. This case is the issue is very simple, but the case is a little unique. Counsel who's here today recently entered in this case. He took over for prior counsel, John Marks. Prior counsel had agreed to produce his client, one of the plaintiffs, for a deposition. We had deposed the other plaintiff. We, in fact, had this second plaintiff, Andrea Chandler, present to appear for a deposition, and counsel canceled it at the last minute due to time constraints. We've rescheduled it multiple times. New counsel entered the case in September of this year. He agreed in writing to produce Andrea Chandler for a deposition post the discovery deadline. I have that attached as an exhibit. The day before the deposition was to take place, counsel informed me he would not present his client for a deposition unless one of two conditions were met. The first was that I would have to produce Sister Layden for a deposition, although that deposition had never been requested by either prior counsel or current counsel at any time. In fact, prior counsel opted out of taking any defense depositions. Counsel said if I would not agree to produce Sister Layden, then if we admitted to liability in this case, then he would produce his client. So essentially what happened, Your Honor, is that counsel agreed in writing to produce his client, reneged on that offer unless I agreed to unreasonable conditions. And, here we are today.
Okay. All right. Mr. Dharamgachin, is that correct?
That is correct, Your Honor. The most important thing that counsel left out is that discovery deadline was August 1st. And I took over after the deadline had already run. So looking at the defendant's motion, there was no court order compelling my client to come in and testify. There was also never an agreement to produce her after the discovery deadline. So after I
There's
took
a letter
over,
that says that there was.
there is no letter that agrees to produce her after the deadline, before the deadline had already run.
Bear with me.
So when I took over,
Just bear with me for a second.
Okay.
I'm sorry. Ms. Salufo, I thought you told me that there was.
Yes, there is.
Where-
Your Honor,
It's exhibit,
it's-
what exhibit?
it's Exhibit F. It's an email from counsel dated Tuesday, September 20th. He said, hello, I just spoke to my client and she is available at this time. Please send me the Zoom link. And that was with regard to the deposition that was scheduled for September 28th. And then counsel wrote to me on September 27th and said.
And I'm
he's
sorry,
not-
when was the deadline?
The deadline was August 1st. And he had, like I said, plaintiff's counsel, prior counsel canceled the deposition several
Yeah,
times.
okay, all right.
Okay.
I got it. All right. So Mr. Dremgotcha, I'm looking at it. I'm looking at an email that you wrote saying that you're going to produce your client after the discovery deadline. Am I missing something?
no, I mean, I was under the impression that the defendant's deposition was already done. And then, so I asked for transcripts from counsel. And that's when I learned that the depositions were never done for the defendant. So I tried to come to an agreement. So, either give us the deposition of your client as well, or admit liability, and we can present, I'm willing to present my client. I just.
Well,
don't
you're
think
going
that's
to present
fair.
your client. You're going to present your client. You agreed in writing to present your client. And then you decided to try to impose conditions on that, which is not okay, Mr. Dremgotcha.
Counsel never told me that the defendant's deposition was never done.
Why is it up to her to tell her? Don't you have a file? That's something you could ascertain?
I had just taken over on September 20th, and I was trying to be accommodating. I wanted to be, I wanted to make it work.
Well, it might have been better to say, I can't make any commitments until I review the file, than to make a commitment and then after the fact, try to impose conditions. Okay, do you two want to agree on a date? Should we put you in a breakout room and you can agree to a date so I can put the date in the order?
Yes, that works for me.
Okay, we can do that.
Okay, all right, and just, and I'm not good at $1,500 for sanctions seems pretty high.
That's fine, Your Honor.
All right, I'm not going to impose monetary sanctions here. Just go in a room and agree on the date, and then I'll put it in the order.
All right, thank you, Your Honor.
Okay, all right, thank you both.
Go back into breakout room number 3, okay?
Thank you.
You were already assigned there, okay? Thank you. Next case, Your Honor, is case number 7. Case number 7. I am going to ask the move-in to identify yourself for the record and who you represent.
Good morning, Your Honor. My name is Michael Byron from the law firm Devlin Associates. I represent the defendants, Elizabeth Hildebert and High Class Limousine LLC.
Thank you. Respondent.
Casey Sirgonic, Your Honor. I represent the plaintiffs.
All right, good morning. Good morning to you both. Mr. Byron, I'll hear from you.
Thank you, Your Honor. This is a motor vehicle case scheduled for arbitration on January 11th, 2023. We served standard discovery. Plaintiff did respond. The issue here is court election status and MRI films. Plaintiff produced, there are 2 plaintiffs. Plaintiff Delvi Laura produced an incomplete policy declaration page. It's 4 pages. Page 2 is missing. The declaration page is produced, state that the policy is a limited tort policy. Plaintiff's counsel has informed me that his position is, I don't have the tort waiver forms from Plaintiff Delvi's policy, therefore she's full tort. I'm asking that plaintiff's counsel produce those tort waiver forms he is insisting on in this limited tort policy. As the plaintiff is in control of that, plaintiff can get that off a website. That's plaintiff's documents. She should produce them. The plaintiff, Letus Laura Maria, has not provided any discovery whatsoever regarding her court election status. She has not stated whether she's full or limited tort. She's not stated, she was a passenger in the vehicle at a different address. She hasn't provided any court status information. They're both have soft tissue claims with chiropractic treatment. As to the MRI films, the plaintiffs have or should have their own medical records and MRI films. The plaintiff is going to go to arbitration, possibly trial, with medical experts who have reviewed those films. Plaintiffs are relying on those films, and they're not producing them. And I submit that they should produce the films if they're going to rely on them, and their experts have had the opportunity to review and rely the films. Thank you, Your Honor.
Okay, thank you. All right, I'll hear your response.
Sure, I'll start with the second one first. I don't have the films, Your Honor. I turned over every medical record I have to the defendant in this case.
Didn't your experts look at the films?
They have the reports. They read the reports, not the films themselves.
Well, why can't you get the films? They're your client's medical records. Why aren't
I
they in
don't
your
need,
client's?
I don't need the films. I don't want the films. If Mr. Byron believes that they will help his case and his defense, they cost money to go get those. And why should my client bear the expense of getting films that they don't need? We have the reports from those films. We don't need the films. If Mr. Byron needs the films, he's more than capable of subpoenaing them from the facility that he believes has the films. It's not my client's burden to produce something that they don't
They're
have.
in your client's possession, custody, or control.
No,
They're
they're
your
not.
client's
They're not in
films.
our
Yes, they
possession.
are.
custody, or
It's your
control.
client's films. Your client can get. I don't know if it's his or her, or their own films. It's their medical records.
Right, but
They're asked
Your
for.
Honor,
They've been asked for them, so they have to go get them.
but again, Your Honor, they cost money for my clients.
Like how much?
I have no idea how much films cost, but they're not cheap. They're the actual
Now, guess
film.
what? We're in a discovery hearing here. If you're claiming that it's unduly burdensome, then that burden is yours to prove that to the court. Telling me you don't know is not proof of
But,
anything
Your Honor,
that's unduly burdensome.
But my obligation is to turn over what I have, not what I don't
No, it is
have.
not. Your obligation is to turn over what is in your client's possession, custody, or control. Your
well, let me-
client controls his or her own medical records. They
Well, let
can
me-
get them from their provider.
Understood. Well, let me turn to the other argument that defense counsel is making then. He's asking me to provide something that doesn't exist. I've requested both the declarations page and the tort waivers from Allstate. They sent me the declarations page. I do not believe they have the tort waivers. If they do not have the tort waivers, my clients are presumptively full tort. If Mr. Byron believes that the tort waivers exist, which I do not believe they do, he can subpoena the file from Allstate. I've requested the file from Allstate. I can't do anything else to make something appear that doesn't exist.
Yeah, but have you said in discovery responses that they don't exist?
Yes, I've told Mr. Byron I don't have them.
No, not that, no. Has it been stated in discovery responses verified by your client that these documents don't exist?
Yes, in the response to request for admissions, I said we do not have possession of tort waivers. Yes.
Okay. All right, Mr. Byron, why aren't you going to Allstate to get it?
Your Honor, because it's, as Your Honor said previously, it's in the possession, custody, or control of the plaintiff.
They've gone to their carrier and they've gotten what they've gotten from the carrier. I think if you want it from the carrier, subpoena the carrier.
Your Honor, respectfully, I'm insured by the same company. I know I can go on the website and I can get my complete policy. The counsel hasn't told you that he's requested the policy. The policy is within the custody and control of the plaintiff. And also that only—
I thought he did tell me that he did request it and he got what he got.
I did.
Well, Mr. Byron, I have no ability to force Allstate to give this to anyone unless somebody subpoenas Allstate. If you subpoena them and they're not responsive, then we'll hold them in here and ask them why they're not giving you the documents.
All right, Your Honor, but that
And
doesn't,
while we're on that, why haven't you subpoenaed the medical records?
because I requested them from plaintiff in their custody and control. And as
You requested them and you didn't get them, so why didn't you subpoena them?
well, I filed the instant motion, Your Honor. And if I can just address the limited court issue, whether he requested the policy for Delvey Laura, what was produced was documentation that it's a limited court policy. And also he's
Well,
produced.
then what else if you have documentation that it's a limited tort policy, what else do you need?
They're married, Your Honor.
Please, I'm not talking to you now. There's
okay.
not interrupting in this court. No,
Okay.
I'm talking to Mr. Byron.
Your Honor, because counsel has made the statement to me in an email, we do not have tort waivers in our possession at this time, so he would be deemed full tort.
You just told me that you have documentation for Davy Laura that is limited tort.
Correct,
Yes or no?
but counsel is taking the position that the declaration page of the policy saying it's a limited tort policy is insufficient, and that the defense of limited tort is an affirmative defense. Therefore, I have to produce these tort waiver forms he says don't exist. Otherwise, she's full tort.
Well,
and also as to the other plaintiff, he's produced nothing. He hasn't even indicated whether she's full or limited tort.
well, do you know that the other party has insurance and who the carrier is?
I
have no idea.
I thought you were
I'm
addressing that to
asking
me, Your Honor.
Mr. Byron.
I have no idea, Your Honor. He hasn't responded.
All right.
One way or the other.
All right, counsel, does the other party have insurance?
They're married, Your Honor. They live together. They're covered by the same policy.
Okay, well,
They have the same name.
have you
Well,
said that? Have you said that in a discovery response?
I believe so.
The complaint.
Well, Mr. Byron, why do you think otherwise? He's saying they're both covered by the same policy.
Because the complaint has two different addresses. If they live together and they're covered by the same policy, that's great.
All right, do they live together or they don't live together?
I don't know why the complaint would say that, but yeah, they are husband and wife. They live together, Your Honor. They're covered by the same policy.
Okay.
Well, but that needs to be said in a verified answer.
I can
Because
do that.
your word as an officer of the court, as great as it is in this forum, it can't be used in court during the arbitration or trial.
Sure, I can do that.
Okay. All right. Mr. Byron, denying your motion. It's up to you to subpoena these documents from the source if you want them.
Okay, Your Honor.
Okay, all right, thank you.
Thank you, Your
Also,
Honor.
you're gonna redo your discovery responses to make it clear.
Yeah, sure. No problem.
Make it clear that they live at the same address
Yes,
and make it clear they're covered by the same policy.
yes.
All right, Mr. Byron, anything else?
No, thank you, Your Honor.
All right.
May we
Just
be
give me a
excused?
minute to do give me a minute, Pete, to do the order then.
Your Honor. Counsel, yes, you're excused.
Thank you. Thank you, Your Honor.
All right, thank you.
Thank you.
Okay. Pete, I'm ready when you are. All right, I think we might have lost Pete. Ah, you're back.
I'm back. Yeah, I was just in the breakout room.
Oh, how are they doing?
They got a date.
Are they we gonna come back and do that or do something else?
It's November the 10th, if you have the
Okay.
order on you.
All right, just give me a minute. They're agreeing it's videotaped?
By Zoom, yes.
Okay, so November 10th?
At 1 p.m. by Zoom.
Okay, just give me a minute.
Yep.
Okay,
All
all right,
right.
done. Ready.
Next case, Your Honor, is case number 10. Case number 10. I'm going to ask the movant to identify themselves for the record and who they represent.
Good morning, Your Honor. Good morning, Peter again. Roger Perry, ROGERPERRY. I'm representing the movant in this case, Janetta Bradford.
Respondent.
Your Honor, good morning. Michael Baumstein, BOMSTEIN. I represent the plaintiff respondent.
All right, good morning to you both. Mr. Perry, I'll hear from you.
Thank you, Your Honor. Just
Your
a
Honor,
moment.
please, may I interrupt? We have a request before the court for a continuance of this hearing based on circumstances laid out in our motion for leave to withdraw as counsel, the premise of which is a potential conflict of interest that has been reported to my carrier. And
Okay, I see. So I'm sorry, do I have a pending request to continue this motion?
very specifically, Your Honor, after the weekend, I was in touch with the court, and
Okay.
I sent a letter to Mr. Devon with a copy to counsel and a copy to my client, asking that this hearing be continued. Mr. Perry filed a timely objection to that request. We were notified to appear this morning. Yesterday, after I had done that, I filed and the court accepted a petition for leave to withdraw as counsel. And that was accepted by the court. It was served on counsel and it was delivered to my client as well. So I believe that needs to be addressed before hearing on the merits.
All right, just bear with me. Just want to take a look. And what's the status of the case in terms of arbitration or trial date?
Yes, Your Honor. The discovery date is November the 7th, Your Honor.
Okay.
Status is it's a major case. And the second, this is a discovery action, and depositions were canceled by Mr. Baumstein pursuant to his representation to the courts today.
Okay, just give me a minute. Okay, well, Mr. Perry, why shouldn't I put off this discovery hearing until the motion to withdraw is heard?
Well, there's two issues, Your Honor. One, of course, is that the discovery deadline in this case has been pending for a long time, and Mr. Baumstein chose only to file the petition to withdraw on the eve of the discovery deadline. The issue in his petition is he claims that there's a potential conflict because of our, we've often mentioned to Mr. Baumstein that we had a healthy skepticism about his client's case, but that matter was before the court and Judge Patrick 6 or 7 months ago, and that's a notice of a potential Dragonetti matter. But Mr. Baumstein's been aware of that for over 6 months. So for him to delay filing a petition to withdraw until the eve of the depositions and the discovery deadline, we feel is not appropriate. He hasn't raised any other classic examples to withdraw, such as there's not been a lack of communication, a lack of payment, and so forth. He's just saying that, oh, because we've raised the skepticism as to his client's case, he may have a conflict. But I don't think that's appropriate enough to, delay this particular matter.
Your Honor, may I respond briefly?
Yeah, sure.
Thank you. What Mr. Perry has left out is that last Friday, his partner and son, Alexander Perry, sent a letter to my office. And in the letter, and I've represented this in my request to Mr. Devon and in my petition for leave, that he was very explicitly stating, basically, that their firm intends to proceed with the Dragonetti case. Now, this is different from the counterclaim that was improperly filed at the outset of the case, which was many months ago. As you know, with the Dragonetti case, you can't file until after the earlier case. The underlying suit has been concluded, and after it's concluded in favor of the defendant. We filed a preliminary objection. For whatever reason, the assigned judge declined to dismiss that and instead put it on hold. I was not cowed by that at the time because, frankly, it's very common these days for a defense counsel immediately to threaten a Dragonetti case unless the plaintiff withdraws. But what has happened that is new is between that date and this past Friday, on several occasions, Mr. Perry, Roger Perry, personally saw fit to suggest that I was, most politely putting it, dissembling. That is, in my personal relations with him concerning my client, and that my client was dishonest. And that was topped off by the letter on Friday that Mr. Perry has seen fit not to mention. Under those circumstances, Your Honor, I felt consistent with my ethical obligations and my obligations under my liability policy. I had a duty to report myself to the carrier. And over the weekend, I sent a detailed 3-page letter to the carrier explaining my concerns. I finally heard back from the carrier on Monday, and claims counsel has advised me, absolutely, I had a duty to seek leave to withdraw and ask for a stay of proceedings to protect my client's interests. I notified my client of that, and I also advised her she may need to consult independent counsel to evaluate her situation. So as it happens, the coincidence of Mr. Roger Perry's son's letter on Friday and the impending discovery deadline was exactly that, a coincidence. There was no deliberate effort on my part or an inadvertent effort to do things at the last minute. There will be no prejudice here. The trial is set for some time in the late spring. There's plenty of time to extend discovery if necessary and extend all the deadlines and give Ms. Sewell an opportunity to find another attorney.
All right, Mr. Perry, do you want to be heard?
Yes, Your Honor. Mr. Baumstein has always reiterated, even to the filings with the court through Peter, that his client has a very valid case. This case involved a approximately $250,000 renovation to a home, so it's a financial matter. And the issue is there's always been a notice to Mr. Baumstein on behalf of his client that we're very skeptical about the filings and so forth. And that's been outlined very specifically in the Dragonetti matter and so forth. So our position is the fact that we notified Mr. Baumstein that we may very well proceed. A, we haven't proceeded, but B, there's nothing new that would change the position of this case, other than Mr. Baumstein apparently may know something in a 3-page letter to his carrier that we are unaware of. But the fact that we're unaware of it doesn't allow the case to be postponed. The prejudice is that we have to, presumably start all over. And unfortunately, we've had other issues where the client goes out, the plaintiff gets new counsel, and they amend and start all over with an entirely new action. And I don't think that's, appropriate here. I think that Ms. Sewell should proceed with depositions and responses to, the discovery we filed.
Okay. I'm not going to hear the discovery motion today. I'm going to schedule the motion to withdraw. Unfortunately, right now, I don't have a secretary who's scheduling me, so I don't know exactly when my next day for motion to withdraw is, but we will figure it out and send out an order on that. Pete, can we kind of put this in some kind of stasis until, I don't want them to have to spend money for another motion if they.
Sure, Your Honor. You tell me to put this motion in advance.
Well, you know what, why don't I find out when we're going to schedule the motion to withdraw, and then I'll be in touch with you about when we'll reschedule it. So we will reschedule this after the motion to withdraw.
Correct. All right, counsel. So right now, court's going to hold this in advance. We'll get a date, and then we'll get a new date for this discovery motion ending in control number 22100708. Okay?
Yeah, and Mr. Bomstein, I think you've been through this with me before, but I do insist that the client have actual notice of the motion to withdraw so that the client can participate in that hearing. If she
Yes,
so
Your Honor.
desires.
So far, we've given her email notice. I've had 2 phone calls with her.
Yeah,
and
well,
I've
you don't have an order scheduling it yet. I'm just telling you because I have the situation too often where it's clear in the order and then we get to the hearing and not you particularly, but that then the lawyer hasn't notified the client and then we have to continue it. So I'm telling you now so that doesn't happen.
Very good.
Okay, all right,
you.
thank you. You're
Thank you,
good.
counsel. You'll get notice from the court. Okay? Thank you.
Thank you.
Thank you, Your Honor.
All right, take care. Have a good day.
Next case, Your Honor, is case number 11. Henry, case number 11. I'm going to ask the movant to identify themselves for the record and who they represent.
Good morning again, Your Honor. Jonathan Rosendahl on behalf of the plaintiff movement, Mr. Martin Henry.
All right, good morning.
Respondent.
Good morning, Your Honor. Vince Savinelli on behalf of respondent Taisha Gray.
All right, good morning. All right, Mr. Rosenau, what's this one about?
Your Honor, good morning. This one is less exciting. This is a motion to compel a deposition. This is a simple motor vehicle accident case involving an August 28th, 2021 accident. We were unaware who the driver of the defendant's vehicle was because the police report only says an owner, and we only have the owner's information. As such, we filed suit on March 25th of this year, just 6 or 7 months after the accident, because it was unclear who the actual driver was. We knew we wanted to leave sufficient time through discovery, written and oral discovery, such as depositions, in order to identify that driver. The defendant admits she's the owner of the vehicle, denies she's the driver. We understand that. The defendant has not said who the driver is, but she is participating in discovery, including issuing discovery to the plaintiff. The defendant did not sign her own verification. Instead, we have counsel's verification, which is not going to get us very far in discovery. The plaintiff is seeking to depose the defendant to find out who the driver is or who potentially could have had access to her vehicle. She's not claiming the vehicle is lost, stolen, absconded with, or otherwise being driven impermissibly.
Okay,
Instead,
did you send a deposition notice?
twice, and they canceled by the defendant, and the defendant canceled them because there's some other person who may have some claim that could be filed at some point prior to the statute of limitations. So they're saying we can't depose her, Ms. Gray, until after the statute. That is the court. If they grant that motion to stay, which is a separate motion, or deny my motion and say I have to wait till after the statute, is forcing my office to commit malpractice by failing to identify the driver within the 2-year statute. When we filed this case 7 months after the accident to avoid the exact issue. Their entire position is they won't allow us to depose the driver to get information that she has.
The owner, not the driver,
The
right?
owner, excuse me. Yes, Your Honor, Ms. Gray. I apologize. We need to know the driver until after the statute passes.
All right, Mr. Savinelli, why aren't you giving the defendant for deposition?
Yes, Your Honor. So if I may, we did supplement the sign verification.
How about answering my question?
Sure.
Why isn't you two notices of deposition? Why hasn't the defendant appeared for deposition?
So the first deposition that was scheduled was actually canceled by plaintiff's counsel, I believe. The second deposition we did cancel. It came to my attention after scheduling the deposition through claims department here that there was another claimant that had an open claim that could potentially file suit. So we therefore contacted plaintiff's counsel's office and explained the issue. Additionally, I
so what? Why is that a reason not to produce the defendant for a deposition?
Well, we don't believe
there's a case by this plaintiff against this defendant. Why haven't you produced that person for deposition?
Understood, Your Honor. In the interest of judicial economy, there would be two potential claims, two potential lawsuits on the same issues. She would be subjected potentially to two depositions on the same issues. So in an interest of protecting my client's interests, we filed the motion to defer.
Go in a room and agree to a date. That is not an appropriate reason to not produce a defendant for a deposition.
Yes, Your Honor.
Counsel, go back into breakout room number 11. I believe you're already in there. See if you get a date, time, and place.
Your Honor, the pending motion to stay or motion to defer would seemingly then, I'm assuming, then be denied. We filed an opposition to that.
I don't have.
It's pending. The 20-day response hasn't.
Mr. Rosenau, the only thing that's in front of me is this motion to compel. It's the only thing I'm deciding.
Understood, Your Honor. We'll get a date and be right back.
Thank you, Your Honor.
Thank you.
Next, Your Honor, is going to be the emergency motion. I believe you have that.
All right. Here, why don't you announce it and then I've got to make my disclosures. Go ahead.
I'm going to ask the movant to identify yourself for the record and who you represent.
Good morning, Your Honor. Terry D'Angelo, and I represent the plaintiff in this action.
Good morning, Your Honor. Jennifer Semian, I represent the defendant, Confluent Medical Technologies, Inc.
Counsel.
Good morning, Your Honor. Carolyn Bomueller on behalf of the Jefferson defendants. I do not take a position on this motion. I'm here as an observer.
Okay, well, I just do want to disclose for the record that my daughter is a resident in neurology at Jefferson. I'm happy to give you a little time if you want to, consider that disclosure before we go forward.
We don't have an issue with that, Your Honor.
I have no issue, Your Honor.
Okay, all right, thank you. Then I'll hear from Movin.
Your Honor, this is a medical negligence products liability mixed case against various defendants, including the defendant Confluent. The case was filed back in April of 2022. There's been preliminary objections, amended complaints, and currently pending before the court are preliminary objections to the second amended complaint. Part of those preliminary objections are in the form of a motion to dismiss for lack of personal jurisdiction against defendant Confluent. The court, I believe on September 16th, issued a rule to show cause as to why the PO should not be granted. And that rule to show cause permitted various avenues of discovery for plaintiff, jurisdictional discovery, including depositions. That is a standard rule to show cause. It's not limited. It does not limit the plaintiff's ability to take more than one deposition. Plaintiff last week and within the jurisdictional discovery period timely requested via a notice of deposition the deposition of John McCune, who is the senior director of sales at Confluent. The defendant, Confluent, maintains that they don't have anything to do with Pennsylvania. They don't do anything in Pennsylvania. Mr. McCune is in Plymouth meeting down the road, and we want to take his deposition.
And I'm sorry, you want to take his deposition for jurisdictional purposes or other purposes?
For jurisdictional purposes.
Okay, just bear with me. Hey, Pete, why do I have this motion instead of Judge Carpenter?
because it was an emergency motion, Your Honor. that was
Oh, I get it.
filed,
Okay.
And I have nobody sitting next week, so you're in.
Oh, I got it. And I'm sorry, what's the emergency?
The emergency, Your Honor, is that the jurisdictional discovery period is ending on November 7th. The notice of dep and the deposition date was for within that period. And in the event that we are not permitted to take Mr. McCune's dep, we would be forever prejudiced in our ability to meaningfully respond to the jurisdictional issue within the preliminary
Okay.
objections.
I'm sorry, what's the date? I just want to look at the rule. What was the date of the rule?
The date of the rule, I believe it's actually the body of the rule says August 31st, 2022. The timestamp of it is September 16th, 2022.
Okay, just give me a minute. Okay, but weren't you supposed to file everything by October 31st?
Your Honor, there was a stipulation to extend the deadlines. That was done jointly and the deadlines were extended. I believe.
Was that stipulation approved? Oh, I see. Judge Andrews approved it. Okay, just give me a minute. I see. So you have until November 7th. Okay. All right. And again, you just want a jurisdictional deposition.
Yes, Your Honor.
Okay. All right. So what's the objection to that?
Well, Your Honor, first, what plaintiff has left out of their motion and in their argument today is they're getting a jurisdictional deposition. They're getting the deposition of the individual who signed an affidavit that was attached to Confluence preliminary objections filed on August 8th of this year. During the discussions over the stipulation for an extension of time, which was requested because that affiant was not available within the original time frame of the jurisdictional discovery deadline, at no time during those discussions did plaintiff ever reference or discuss the deposition of Mr. McCune. That never came up. They've known about Mr. McCune at least since the time that they filed their opposition to the preliminary objections on August 29th of 22.
Well, didn't they notice Mr. McCune?
They noticed Mr. McCune on October 28th at 6:38 p.m. in a notice that reads not Mr. McCune as a fact witness, Your Honor, but Mr. McCune as a corporate designee of defendant Confluent, something that's procedurally and substantively deficient. They don't get to select who a corporate designee of a defendant is, and the notice itself.
Okay, all right. Where can I see that? Where can I see their notice? Is their notice attached to something?
Their notice should be attached to their motion, Your Honor.
Well, it should be. Can you help me out on what exhibit that might be?
Your Honor, I do not believe the notice is attached to the underlying motion, and I don't want to get into an argument without Your Honor's permission.
No, please.
However,
Okay, so wait, so you got a, well, wait, just bear with me. Well, it looks like it is. Okay, all right. Just bear with me. Okay, I've got the notice in front of me.
Okay, Your Honor. So as you see, the notice clearly says John McCune, corporate designee of defendant Confluent. And then under the notice, there are no areas of inquiry. There is no discussion pursuit, which would be required under Rule 4007.1E of the Pennsylvania Rules of Procedure, setting forth the things that they want Mr. McCune to testify about. So the notice is substantively and procedurally defective, and for that reason alone, the court should deny the plaintiff's motion. But I really want to talk about this question that the plaintiff raised with respect to resulting prejudice. There's no prejudice here. They're getting the deposition of the individual who executed the affidavit. That individual has testified Confluent is not registered to do business in Pennsylvania, is not incorporated in Pennsylvania, and does not have offices in Pennsylvania. This sales representative that they're looking for has never been involved in the sale of products related to this product line. And Your Honor, when we're talking,
why aren't they entitled to take his deposition on that?
They can get that information from the individual who signed the affidavit. I don't think they need multiple depositions on this issue, Your Honor. And here's why this is important. Let me get back to the prejudice piece for just a moment, Your Honor. When we're looking at general jurisdiction and specific jurisdiction in this case, Confluent as an entity did not even exist until after 2006. The allegations at issue in this case are that a medical device that was implanted in the plaintiff in 2006 was defective. Confluent could not possibly have manufactured the component part that was installed in that device because they didn't exist at that time period. So what is the purpose of deposing a sales representative regarding a product that Confluent could not possibly have manufactured at the time period that's at issue in this case? It is per se bad faith to notice that deposition in the first instance. But if they want answers to that question, they're getting the opportunity to ask those questions during the deposition of the individual, John Witt, who executed the affidavit in support of Confluent's preliminary objections. And for that reason, Your Honor, we'd ask that you deny the motion.
Okay, Mr. D'Angelo, why do you need this guy when they're giving you the affiant?
Just briefly, we need the deposition of this individual and are permitted to take more than one deposition, obviously, because he has information directly relevant to and is the closest person to the activities of Confluent within Pennsylvania. And we're arguing jurisdictional discovery. I'm flying to California to meet with the affiant. He's not in Pennsylvania. He's nowhere near Pennsylvania. And it's our position that we would need the additional deposition of this individual because he works in Pennsylvania. Presumably his office is in Pennsylvania. He's intimately familiar with all of the sales that Confluent conducts within Pennsylvania. And Mr. Witt's characterizations of what they do in Pennsylvania would be more appropriate truly for Mr. McCune, who is there. In addition, Your Honor.
Why'd you wait till October 28th to notice the deposition?
Your Honor, initially in reviewing the affidavit of Mr. Witt, we were not going to take any additional depositions, but after consulting with various colleagues, the decision was made to take additional depositions, namely and only and limited to the second deposition of Mr. McCune. And that is the only reason why while being filed while being timely, it was not requested sooner. That said,
why does it say that it's a corporate designee deposition when A, you don't get to pick the corporate designee, and B, it doesn't have any areas for any subject matters of the deposition listed?
Your Honor, the notice of deposition identifies in the body of the notice John McCune as the Senior Director of Sales at Confluent, not as the corporate.
Why does it say in the title that it's a corporate designee deposition?
I can certainly amend that. It makes no difference to me whether or not it's a corporate designee deposition or a fact witness deposition. I'm certainly amenable to amending it.
Did you intend to take a corporate designee deposition?
I intended to take the deposition of John McCune.
Okay. And I'm sorry, discovery ends now on Monday?
It ends on Monday.
Sorry.
It ends on Monday. Obviously, Your Honor, we're as you'd imagine, we're willing to extend the deadline by a week or what have you to accommodate Mr. McCune or counsel.
Okay. All right. Well, go into a room and pick a date. Because I'm ordering the deposition.
Your Honor, I'd have to talk to the witness. I've not done that, so I don't know his availability.
Okay. Go into a breakout room and call the witness and get his availability.
Okay, Your Honor.
All right. Thank you.
Thank you. Go back in the breakout room. Pick any breakout room. They're all open, okay?
23.
23. I don't know, whatever breakout room you were just in, go back into that room.
Thank you.
Yep.
All right. Thank you. Pete, do we have a date on number 11?
We do, Your Honor.
Okay. Is it in person, by Zoom?
It's going to be by Zoom.
Okay,
The date is November the 22nd.
okay, just give me a second, Cheryl. Yeah. I'm sorry, say again, on
November
November
22nd
at 10 a.m.
at 10 a.m. Yep. It's in the chat. Yep.
Okay. Okay, well, so while they're finding a date, I'm gonna go see if I can find a date for my motion to withdraw.
Okay.
So I'm gonna stop video and I shall return.
You got it, Your Honor. Thank you.
Thank you. Pete, I'm ready when you're ready.
Okay, Your Honor. Yeah, I'm going to jump in to the breakout room. Or do you have-
Okay, because I want to talk, the motion to withdraw, I'd rather talk to you after we're.
Okay. All right. Yep. Let me see where they got there at 23 because we're still live streaming. Right, Cal, Your Honor, we got all counsel here. Steph, you good?
Yes, thanks.
Your Honor, this is case number 23, recalling case number 23.
Okay.
Your Honor, I was able to speak to National Counsel, but I was unable to reach the witness directly. So we think that November 15th is going to work. We're working as quickly as we can to confirm that with the witness. And our proposal is then that we move the supplemental briefing under Judge Anders' August 29, 2022 order to November 28th, right, Terry?
November 30th.
Okay.
Okay, well, I can't do that on behalf of Judge Anders.
Okay.
But
We'll
I can ask him.
We can always file another stipulation, Your Honor, if that's easier for you.
Well, I mean, I talk to him 20 times a day anyway.
Okay. I'm trying not to put work on your desk, Your Honor, but.
Your Honor, at this present time, Your Honor, this is Judge Carpenter's case, so.
But it's
if they
Judge
want to get a
Anders.
stipulation, they could get the stipulation, email it over to me, and then I can take it down to Judge Carpenter. All
Okay,
right.
but it's Judge Anders' briefing order. And did it move from his program to her program?
Yes, Your Honor.
Oh, okay. Yeah, I think that's probably the easiest if you do. Sorry, it's just like it's just our division of labor.
We already have a draft stipulation from the last round of an extension, so adding one here is not much work on our behalf, Your Honor.
Yeah, just get it over to me. I'll get it down to Judge Carpenter.
Okay, well, shall I put the 15th in the order, or should I just say within 14 days or something like that?
That would be helpful, Your Honor, just in case we end up with needing to move it.
Mr. D'Angelo, you all right if I put that they have to do it within 14 days of this order?
Absolutely.
Okay. Okay, all right, done.
Your Honor, if just briefly, if I could ask Your Honor's guidance, I probably not, but I will.
Probably not, but I'll listen.
I'm anticipating objections to the notice of deposition, and I would ask your guidance, Your Honor's guidance on.
You haven't done a notice yet, so. So no, I'm not.
Very well.
I'm not giving advisory opinions. I'll just tell you that noticing an individual is different from noticing a corporate designee. So read the rules.
Understood.
Thank you, counsel. You'll get a notification of your order. Get that stipulation again, circulate it with all counsel, send it over to me. I'll get it down to Judge Carpenter, okay?
No problem. Terry, I'll send that to you shortly. Thank you so much, Pete. Thank you, Your Honor.
Thank you.
All right,
Thank you, Your Honor.
Thank you,
Thanks, Pete.
everyone. Take care. Have a good day.
Bye-bye.
Bye.
Your Honor, that concludes your discovery list. Can I adjourn court?